Hi everyone, this is Matt with ESI Survival Guide. We're an online resource designed to help legal professionals navigate the electronic wilderness. And I want to welcome you all to a video discussion with Kelly Twigger. But before we dive into a conversation that I'm really excited to have, let me just give you all the old obligatory disclaimer, which may or may not apply to Kelly because she owns her businesses. But let me give it to you. The views expressed on today's session are those of the individual interviewers and interviewees and our individual capacities only, not those of our respective employers. I also want to direct you to the disclaimer on the website, somewhere towards the bottom. There's lots of good legalese in there. And with that, Kelly, this is really, really awesome that you're here. Thank you for joining us on the guide.
Oh, yeah. Thanks for having me. I appreciate it.
Awesome. And I've been a fan for quite some time. I joined this industry back in 2008, and you were one of the original academic practitioners that I followed. You know, I'm sure our paths crossed at a Legal Tech or a Relfest or an EDI or some other conference, but actually this is the first time we've had a chance to sit down and talk like this. So again, thank you tons for taking time to join us. And Kelly, if you will indulge me for a bit, for anyone in this space, you need no introduction, but if I may, Kelly is principal at ESI Attorneys, founded in 2009. It's an information law and eDiscovery law firm in Colorado. And Kelly's been in the data law space for over 20 years. And not only did you build clone computers in high school, if my research is correct, but you built the first eDiscovery and records retention practice at Quarles and Brady on top of being a litigation partner. Kelly is a prolific writer on eDiscovery Bytes Blog, which you also founded. She co-authored the book on electronic discovery and records and information management. It's the rules, checklists, and forms guide. And Kelly, I believe the 2020-2021 edition is now available at the Westlaw store. Is that correct?
I think so, yeah.
Awesome. And one of my favorite things, because I'm a huge case law nerd, I am a big fan of the new Case of the Week video series, which I'm going to touch on today. You know, the speaking gigs and the pieces that you've drafted, you're a data lawyer's data lawyer. And I say that because you're able to dive in and really unpack the legal and tech aspects of everything from data mapping, GPS data, mobile discovery, eDiscovery ethics, and a whole lot more. And in reading many of your pieces, you've been so consistent, you know, identifying and charting out best practices over the years that were as forward-leaning then as they still are today. So one thing I'll say too is, Kelly, our session today is geared towards both beginners and experts alike. Mm-hmm. So if any terminology comes up that I think might need to be defined, I might ask you to do that. Sure. And I'll include some resources in the commentary below that you've created, which I know are going to be very helpful to our viewers. I know for this session, they're coming to listen to you and get those resources and not so much listen to me at all. But with that, let's start cutting a trail through the wilderness. Does that sound good?
Sure, sounds great.
Awesome. So first question, jumping in, you know, competence is the hallmark of the legal profession. You're someone that stayed well ahead of the curve with regards to technological know-how for your entire career. Right now, there's so many challenges that attorneys are facing. There's the proliferation of chat and collaboration data because everyone's working remotely now, advancements in artificial intelligence. It seems like more new regulations coming out every day than there ever has been that are related to data lawyers. Maintaining competence can seem really daunting. So first, you know, what does competence mean to you in the digital age of law? And second, following that, what do you think right now is the single biggest challenge that's facing legal practitioners in the digital age?
So there's a lot to unpack there, right? But first of all, thanks for having me. I really appreciate the opportunity to sit down and talk, and I'm excited about your newly revamped website, so I can't wait to see it. I think with regard to competence, that competence depends on who you are, where you're practicing, what your cases are that you're taking on. So there's no one definition of competence that covers all attorneys. When you're talking about eDiscovery competence, which is a subset of that when it comes to legal technology, there's a decision, I believe it was from 2015, maybe 2016 from California, an ethics decision, which you could attach, I can send to you and you could attach to the resources here, that really lays out it's a very well-written decision from the Ethics Commission on what eDiscovery competence means. And there are really three options that opinion lays out. One, you can get competent yourself, and there's a list of 9 different things that you need to be competent in that are laid out in that decision. 2, you can hire somebody else to help you with those things. And a lot of times our firm, that's where we get brought in by other law firms or organizations. Or 3, you can decline the representation. So I think when it comes to ESI, which is, I'm going to kind of limit my focus on the competence question to that you need to know what you need to know for your practice. So if you're a plaintiff's attorney taking on large class actions, your level of competence is going to be more technical and higher requirement than someone who's doing more family law. So, family law has its own ESI challenges, and there's a subset of things that we talk about to family law lawyers about, what they need to know and kinds of things they need to be thinking about all the time in preserving information. But it's a totally different thing. So competence means whatever competence is for your particular practice area and for your practice, the types of cases that you take on. If you're bringing cases against large tech companies, you're going to need to understand the systems that large tech companies engage in.
Yeah, I mean, you bring up something really interesting with regards to that opinion. And I recently wrote a blog article on competence. It sounds like I need to update it with that opinion you mentioned. But that third category of declining the representation. So do you think there's a lot of issues and problems that happen in discovery because counsel, who might be a substantive subject matter expert on the actual case itself, and the underlying subject matter, they wade into discovery, maybe realize they're in over their head, and they either can or don't decline? I mean, isn't it difficult for someone to maybe decline the representation before they know the full scope of what they might face in eDiscovery?
Yes and no. I would say if you told me the kind of case that you have, I could tell you the scope of what your discovery issues are going to be as they relate to ESI. Obviously not all the way across the board, but pretty quickly, right? So, if I know what the case is about, what the claims are, what kind of company it is, what the age of the custodians are, those kinds of things, I'm going to know pretty quickly what types of information are going to be at issue and what you need to know and what kinds of things you need to focus on. For example, if you're dealing with a lot of third parties, you need to start that as early as possible, because the likelihood is that those third parties are not going to give you data within 30 days. And it's going to take months and months and months of following up to get that information. And then if you don't get it until after the close of discovery, you have no ability to follow up on the information either with the third party or with the party in the litigation based on what you get from the third party. So there is a level of competence that if you don't have it going into litigation, you will be at a disadvantage. I was talking to somebody this morning about our approach from the firm's perspective, and we sit down with clients at the outset of a new piece of litigation and really strategize with them about what the goals are of the litigation, what the cost will likely be as it pertains to discovery, what kinds of sources we view. And we have a firm understanding right away of what needs to be done. Because, as you know, there are a lot of sources of ESI that can go poof pretty quickly if you don't take active steps to preserve. So I do think that a lack of competence in understanding ESI and issues that may come up in discovery in your case can hurt you from the get-go. But I also think that what you're saying is that when you get into discovery and you realize that you're over your head, can you get help then? And I would say absolutely. So everybody gets in over their head at some point about something, whether it's litigation or discovery or something else. And I think if you realize that you need help at that point, that's when you get help.
That goes to the whole notion of competence being not as much or just as much about what you don't know as what you know. And I think, it's interesting because I know so many lawyers, if they're working on, let's say, like a heart stent infringement case or something like this, they'll learn all sorts of things about heart stents and become pseudo experts in it up to a point and then engage outside experts. Right. Discovery, it seems like despite the fact that it's become a really technical endeavor, people still seem to have kind of that dearth of knowing when to cross that line of really jumping in and learning what you can and then kind of when to get help. And that kind of leads into that second part of the question. What do you think right now is the single biggest challenge that legal practitioners face in the digital age of law?
From an ESI perspective, again, I think that the biggest challenge is the constantly changing technology. It's constantly changing. Even updates that are made to Office 365, which is a technology that's being rolled out in organizations around the world all the time, changes to WhatsApp and Facebook. If you followed recently in the press, the changes to the privacy policy that WhatsApp tried to impose upon, or that Facebook tried to impose upon WhatsApp users, because Facebook owns WhatsApp. And a number of WhatsApp users, well, hundreds of thousands of them, like said, see ya, we're going to go use something else, because they changed those privacy policies. So staying up to speed on these things is difficult for me. And I do this 24/7. So it's,
Right.
we have, in response to the 2016 election, the social media platforms changed their APIs to be able to combat misinformation for the election. And that changed our ability to collect information from those. So all of the collection tools that work for social media had to make adjustments, and some of them still are. And we're not getting the same kind of collection that we were getting pre the election. So there's so many things happening all the time. What you need to know are, what are the things that you need to know, and who are the people that you can call to get the right answers when you need them.
Do you think you would have said that when you first began practicing? Would you have also identified the biggest challenge being the change in the updates in technology, or would it have been something different?
Well, I started practicing a really long time.
I'm not
sure
trying
if
to
that's a good question or not. But when I started
I'm not trying to call you out on that.
No. When I started practicing, summation was the ultimate technology. And
Right.
then, I spent a lot of time as head of our group at Quarles and Brady, looking at new technologies and seeing what was happening. But no, we were not seeing the speed. We didn't even have the cloud at that point, right? Everything was still on-prem software. We were still using GroupWise.
Right.
So, no, I wouldn't say that. The technological advancements within the last decade have been exponential compared to what they were in the previous decade. I mean, we didn't even have cell phones.
It's funny to look back. I mean, when I started, I did a couple of doc review projects. We were in a platform called Xantaz. Email threading wasn't so much a technology as it was just a group of 10 people stacking papers together.
That's right. Yeah. Yeah. I mean, when I started, and I've said this before, when I started, we only had yellow sticky notes. There were no multicolored sticky notes, right? So you had yellow sticky notes.
There wasn't even color back then. Everything was
cut the sticky notes over the part you wanted redacted, and you wrote redact all over it. And then you wrote responsive, privileged, whatever, however your little system was. And then ultimately we got colored tabs, and so you could color tab things, I mean,
thinking about that path too that you traveled, and I'm going to jump around a little bit. I apologize. So there's so much I want to talk to you about, and hopefully you'll come back. But you're extremely prolific in the eDiscovery world. You've had a very unique long path that I know is just going to continue on and on and on, and into different roles and different areas. You played the role of trailblazing attorney, entrepreneur, academic. You've created this eDiscovery Bytes blog. You created I think one of, if not the first ever eDiscovery focused firm, ESI Attorneys, and the most comprehensive, I feel safe in saying, the most comprehensive eDiscovery case law and resource database on the web, eDiscovery Assistant. Walk me through, what's the impetus behind this entrepreneurial path? I mean, were you this way when you first began, trying to find new ways to solve issues that you saw no solution towards, or did that develop over time as you got more involved in eDiscovery? What drives you in that regard?
I would say I've always had an entrepreneurial mindset, and I'm a problem solver. So when something comes up that needs a new solution, I just find a solution for it, So I think doing litigation, I mean, the thing that I love the most about litigation is I love the strategy. I love litigation strategy, and being in Discovery now lets me marry that litigation strategy with the technical stuff. So I love that. And I guess I kind of always envisioned starting a firm, and was really, really fortunate to have the experiences that I had at Corals and Brady, and the lawyers that I got to work with were very top notch. But I also had some really unique things. You know, I took my first deposition the afternoon or the next day after being sworn into the bar. So,
Okay.
you know, and
Trial by fire?
I'm sorry?
Trial by fire?
Yeah,
Right?
well, you know, I was taking expert depositions in my first year as an associate. So, you know, there were a lot of opportunities that I got very early on to understand the importance of discovery strategy and everything that was associated with it. We were dealing with spoliation issues and attorney-client privilege issues. I mean, I had a motion on a case involving screws where we made a motion to dismiss for spoliation related to the screws, not even ESI, just totally related to screws. And so I think that a lot of that is built. And then as ESI issues came about, so I graduated from law school in 97. As ESI issues started to come about in 2002, 2003, I was working with clients on a lot of that data related information, and our ESI practice kind of naturally came out of that. I happened to attend an event in New York in 2004 and came back to the firm and said, you know, we've really got to get our arms around this as a firm. So started our program there. And that really led to a lot of work, and a lot of work with clients on these kinds of data related issues, whether it became data mapping. I spent a lot of time sitting down with IT people, and one of the greatest things you have to be able to do is to ask questions you don't know the answers to so you can learn. And that's what I did. I spent a lot of time doing that. So, you know, when I left and started ESI Attorneys, it was with a completely different business model in mind than a traditional law firm. So we partner with our clients in a little bit different way than outside counsel do, to the point where we're effectively outsourced in-house counsel. And our goal is to be a part of the operations of the legal department and of the business so that we can constantly help issue spot data related issues. So whether that's how to set up appropriate governance in Office 365, whether team calls, the video can be enabled by the administrator, or whether each person turning on a team call can enable it, and where those get stored. We've had a lot of governance issues during COVID. So it just kind of evolved that way. And then when I left and started ESI, it was just sort of a no-brainer, and it's worked out really well, and we've really enjoyed the practice. eDiscovery Assistant came along because I needed a tool that allowed me to know the case law and the rules for a particular jurisdiction on demand. That's what I needed. I get a phone call from a client and they'll say, hey, we have a new distributor case in the Southern District of Florida. And I immediately say, okay, who's the judge? What are we looking at? And then, you know, I'm on eDiscovery Assistant and I'm pulling up the decisions from that judge and looking at where I think the issues are. And so that's what the impetus for eDiscovery Assistant was. It's been a lot of fun, and we're building on it. So I'm glad to hear that it's a valuable resource for you.
Yeah, I mean, I love that, because one of the things I love about eDiscovery is the nascent nature of it. Even though it's been a growing industry for, I guess, you know, a couple decades now, it's, you know, when you can find folks that marry that entrepreneurial spirit with all the changes that are happening, someone like you that literally has a need and just builds a solution rather than kind of wait for it to come out, I think it's pretty cool. And I think that a lot of folks coming out of law school, you know, really need to embody that kind of spirit. And right now is such a unique time. It's not just because of COVID and all the other issues that are happening, but also just because of the state of the legal profession in law schools generally. And I think now you're seeing a lot of atypical, if not non-traditional paths for folks with law degrees to take. And eDiscovery, of course, is one of those big doors. The flip side of the entrepreneurial coin, if I can address the elephant in the room, is I know that many listeners are saying, wait a second, she was a litigation partner at a mega firm that has a great reputation and she left to go do this. I assume that was a very difficult decision, but I know that in this day and age, those type of scary, difficult decisions are really what a lot of folks need to embrace to kind of build their career and take advantage of these new opportunities. So can you, like, was that a difficult choice, or was it an easy choice? I mean, again, when I was in law school, becoming a partner, that's what you aimed for. There was nothing above that. Maybe going in-house, but so that
I did that. See, I became a partner, and then,
that's what I'm saying. Like, to transition from that to say, okay, I have this. Now I'm going to go into the uncertain world of starting a business. That seems, I think, to many people to be a really unique choice. And I love to hear, what was your, how were you feeling during that time? Was it scary, or you were so driven to do it that it didn't even cross your mind?
I had a lot of confidence in the model that we were looking at from knowing that eDiscovery was going to be an enormous, brand new substantive area of the law, and that specialization, and although we're not supposed to use that term, competence in the area was going to be a need. And I was probably ahead of the curve from that perspective in starting the firm. But our clients are the ones who get it and who know and understand that there's a lot of value in doing eDiscovery effectively, and in partnering with folks who can help them constantly assess risk and evaluate needs, so that they're getting to spend time, that the trial lawyers are getting to spend time on what they actually need to spend time on instead of reviewing documents. I can't say that there was, there's always uncertainty, right? But I guess by the time I'd left the firm, I'd already had 3 kids and saved for 3 maternity leaves. And so I guess not really. It wasn't really a fear kind of thing. I guess I'm a bit of a risk taker from that perspective, but I don't really think about it that way.
Sure. Well, sometimes, it's like Wile E. Coyote, right? When he runs over the cliff.
I'm not sure I want to be compared to Wile E. Coyote. I'm not.
I didn't mean it like that, but
I know
what I mean. It's like,
okay.
Sometimes when you don't focus on the fear, that's how you get stuff done and kind of cross over. But it definitely sounds like, you have a bit of a crystal ball. I mean, you were able to really see eDiscovery was going to be something huge, and there was a need. So maybe off camera, in light of what the Powerball's been hitting lately, I'll ask you for some numbers.
All right.
So,
no problem.
So going back, you mentioned eDiscovery Assistant. So I want to make sure that we also give our viewers some really good practical advice and practical resources. eDiscovery Assistant is something that I wish I had access to from the dawn of my career. To be honest, and not to butter you up, but it's one of the most helpful resources I've begun using lately. And even when there was only a handful of eDiscovery opinions, it would have been helpful. But now there's dozens coming out each week. Can you talk a little bit about eDiscovery Assistant, and how can somebody watching this video at the end of it get the most benefit from eDiscovery Assistant and start using it today?
Sure, absolutely. So eDiscovery Assistant is a tool that, like I said, we built originally for use at our firm. And what we do is we curate from all of the domestic decisions, anything in the United States, whether it's federal courts, federal district courts, state courts, eDiscovery decisions that come out. We include both published and published decisions in the case law database. So there are 5 areas of content in the database. There's case law. We also curated all the discovery rules, checklists, forms, and then a glossary of terms. And then some of the things that make the database really unique, or the tool really unique, is that we created a tagging structure of issues. And so I think there are about, just under 80 issues in eDiscovery that we created. And so they can be high level, from failure to preserve, to granular in GPS. And our content team reviews all the cases that come through the back end, decides what goes into the database, and then they are tagged with our issues. And so if you use the database to conduct research, standard research platforms, it can take hours to get to the results that you actually need to review. And eDiscovery Assistant, generally, the way that we use it, gets us to the cases that we need to look at in just a few clicks. So that was the goal in creating the tool, and that's really where we're driving to. So it's the things that we're starting to build now are a learning center to go along with it. So we can do short video segments on different aspects of eDiscovery for learning purposes. We're doing a lot of education. So in terms of accessing it, anyone can go sign up for a free trial at eDiscoveryassistant.com, and that'll give you a free 30-day trial. If you're a law student, and you want to have an account, we offer accounts for free for law students. We have, trying to remember exactly how many, I think 20 or 25 law schools that use eDiscovery Assistant for their eDiscovery classes or their discovery classes. And so we just talked with another one this morning.
That's great.
And so we'd love for you to be able to leverage the resources. Sometimes we'll sit down with the professors and do a little walkthrough for the class as well, and show them how they can leverage it for specific topics. So.
Yeah, I mean, that's great that you're partnering with law schools. I think when I was in law school, the most exposure I had to technology was probably listening to my CD player in lecture class when I should have been taking notes. But no, I mean, one aspect of eDiscovery Assistant that I really like too, and feel free to expand on this and correct me if I'm describing it incorrectly, is that it also organizes kind of new cases into 3 topics for the week. Is that correct? There's kind of a topical organization.
So our dashboard will include the top 3 tags for that week. So I think actually, as I was looking at it today, it was failure to produce, proportionality, and cost recovery, maybe. So they change every day depending on the cases that go in. So our case team on the dashboard, it'll show you the number of cases that have been added in the last 7 days, the total number of cases that are in the database, and then the top 3 issues from the last 7 days. So those will change on a regular basis. You can click on those issues and just run an issue search across the database. You can go to the recent case law that's been added at the bottom of the dashboard. We have a case map that shows you the cases across jurisdictions in federal and state. So it can be helpful from that perspective. And then whenever you go to case law and you run a search, you can use any number of filters. You can use our issues, which is where we encourage you to start. That you can use your own search terms. There's Boolean searching that you can apply then, date filters. And then we also allow you to search by your judge, which is great when you're trying to drill down specifically to decisions for your judge. And then from a jurisdiction perspective, you can drill down into the individual district courts within the circuit court. So within Florida, you can do the Middle District, Southern District, Northern District, which is really helpful when you want to know if your judge hasn't said anything on proportionality, what did the guy down the hall say?
Sure. Yeah, and I think if there's one survival tip for viewers of this session, I mean, that's it, is to check out that resource. And we'll put a link to it in the text. But you also spoke about some of the video content that you do and some other educational resources. You recently launched Case of the Week on YouTube, and I know that it also feeds through LinkedIn with some really great content. That's a joint effort between eDiscovery Assistant and ACEDS. And what I really like about that is, you're not just kind of parroting off a decision and what an order says. You're really weaving in your expertise and your experience over the years with that case, which I really like. I was happy to see your inaugural video where you talked about Magistrate Judge William Matthewman's case, that EEOC v. M1 5100 Corporation, and again jumping around a little bit. I know we talked a little bit about this, and I think it relates to competence significantly, but the perils of self-collection. This is something that I've experienced and come up with a client this week already. It happens all the time. But in this case, during the meet and confer process, defense counsel stated that they didn't know how their client went about collecting documents. Clearly a 26G violation, but you don't see a lot of ethical inquiries when it comes to competence in the eDiscovery space. Doesn't this type of behavior border on an ethical violation with regards to that duty of competence?
Yes and no. I mean, I think that in this particular situation, or at least the facts as they're articulated by Judge Matthewman, and I'm lucky enough to have chaired panels with Judge Matthewman at the UF conference, and he is a very not only a terrific jurist, but he was a trial lawyer who dealt with ESI issues before he got onto the bench. So he's got trial experience with the issues that he's writing about and talking about. And I think in that case, his point was, look, you can't just tell your client to go and get the information. And there are a couple of reasons why. One, they have their own self-interest. And 2, they don't understand the scope of what is relevant within the context of litigation. And it is your job as the lawyer or the legal professional who's being supervised by a lawyer to make sure that the client is hitting on those points. And so, your question was, is that a competence failure? Probably. But if we are looking at every competence failure in ESI related issues, I think the bar associations would have a lot of problems.
The legal system would come to a grinding halt, right?
So I think that we need more education. We need more people doing it, you know, and understanding and recognizing it. I think one of the challenges we've had is those same bar associations refuse to recognize that electronic discovery is its own substantive area of the law. And I think if you're in eDiscovery and you, I mean, there are 80 issues in eDiscovery Assistant alone. That's, I mean, like, if you can't get that it's its own substantive area of the law that people need to be up to speed on, you know, that's fundamentally going to cause a problem when our governing organizations aren't recognizing it.
Well, you work with a lot of law schools. Are you seeing, I've spoken at a few law schools, and typically the e-discovery aspects of law are relegated to one lecture as part of a civil procedure class. With the schools you're working with, are these separate classes focused on data law or e-discovery that are separate from more procedural kind of discovery-based classes?
They are. Each one of the schools that we work with have their own either electronic discovery or discovery skills class.
That's
and
awesome.
So we try to work with them in whatever makes sense for their syllabus to provide information. So it may be one that I spoke to today where we're going to cover a 2-hour session really of most ESI issues, but they've got information that they will have already covered about legal holds and other topics in their class. So we'll kind of skip over those things. But again, you know, I think that where we are in education is improving. We got a lot of things going on. Bill Hamilton at the University of Florida is doing amazing things with his program. Craig Ball teaches at Texas. He teaches a really technical class where he's teaching a lot of detail about how technology works and things you need to think about. Lots of folks like yourself who are providing an education are teaching classes all over the country. And so I think we just need to keep growing that. The hard part about it, though, because people ask me, why don't we have more? The hard part is, in order to be able to really do it effectively, you have to have someone teaching it who's doing this stuff day in and day out, who's actually applying the concepts, the theoretical, the legal concepts to the practical. And to do that, it takes a lot of time and energy to put a class together like that and to be able to teach it and to be a professional. And, you know, law schools have full-time faculty and there are adjunct positions for these kinds of things. But it's difficult to, one, get the right people, and two, have the right people have the amount of time and energy really to pull together a whole program. So
it seems like, you know, traditionally law schools really wanted to focus on kind of the broad topics so that they weren't backing people into a corner so they'd have to apply certain things. And I think that's why practical skills were always pushed to the side a little bit for bigger legal concepts that folks could apply to novel fact patterns. But in eDiscovery, it's a marriage of those two things, very practical know-how plus the larger jurisprudence. But you gave a shout out to Craig Ball. I figured since you did that, I would also just say Craig Ball, definitely his blog, Ball in Your Court, has some very detailed practical posts. And the guide actually syndicates his content. So not all of it, but there's a lot of his posts that actually go on the guide. So we're very happy for that as well. But
if you're naming resources, I would also include Doug Austin's eDiscovery Today blog. Is a great one to follow for a lot of information.
Definitely.
The Relativity blog is also a great blog to follow for information that is not just relativity, but more industry-wide related in a different way, two very different resources. So those are some of the good ones.
Yep, and I'd also throw Greg Buckles' eDiscovery Journal out there, and also Chris Dale's Disclosure Project for kind of the across the pond and in the global perspective. Right. Yeah,
all very different, all different information, all different perspectives, and different kinds of writing. So yeah, it's great.
Yeah, the academic world is definitely robust, which is it's great to even remotely play a role in that. But going back to the self-collection, so without digging up any dirt or getting too into specifics, this self-collection issue, again, in the past week, I've had two major firms where, although eDiscovery and self-collection, the self-collection efforts were supervised, there was still almost this reluctance to really put the client's feet to the fire and say, look, here are the consequences. You have to do this stuff. this is what you could face, and I'm only telling you these things because I don't want to jeopardize your position downstream if discovery is challenged. I'm sure in your role you've come across lots of clients who maybe weren't so cooperative. Can you give us an anecdote about maybe a situation where you kind of had a little more of a pugilistic relationship with a client who's been doing self-collections? And if so, what did you do to overcome that situation?
I haven't had self-collection issues at ESI Attorneys because that's part of how we work with clients. So that's kind of how we lay things out. This is what has to happen. And if you don't want to do it this way, then that's fine. But maybe you need to find somebody else to work with.
Sure.
I'm not afraid to say that. And maybe that's a benefit of heading the firm, is that we can take that position. I think that oftentimes the problem is that the in-house counsel have a legitimate concern of balance. And their concern is that outside counsel want to come in and broadly over collect. And so the way that we address those kinds of concerns when we have them with clients is to show them why we're doing what we're doing. So for example, if we're collecting from Office 365 and we run searches and we get inconsistent results with the way that we're running searches, then maybe we pull more broadly by custodian for a particular date range rather than limiting the search to search terms for that particular custodian. And we have to explain to outside counsel or in-house counsel why we're doing that. So understanding the technology, being able to iterate on the platforms, those are ways to be able to get past those issues with clients. But I also think that at some point, the clients have to be willing to take on that risk as well. Sure. The challenge that you run into is Rule 26G, right? Because Rule 26G says that you've signed off that these documents are all the documents that are responsive to these requests. And if you don't know that the collection that you made pulled in all the responsive documents, you really can't sign those requests. So that's another point to have a discussion with your client about, that you can't put yourself on the line until you know. And so then you need to look at options, right? Like if you're concerned that the client is under collecting on a particular way, what kinds of searches can you run, or what kind of sampling can you do from that same collection that will give you the assuredness you need as outside counsel to be able to sign those requests? So you have to think a little creatively in those kinds of situations with clients, but it's not something we face that much. But frankly, that's because the people who hire us as discovery counsel are coming specifically because they want someone to guide them from that perspective.
Sure. Well, if I could distill a survival tip from that, it's don't be afraid to have the conversation, right? And I think a lot of people don't take that advice. But pivoting from that, you mentioned in-house counsel's concern over outside counsel going hog wild with collection efforts and collecting too much, which kind of begs the proportionality question. One issue that I know is really big in the eDiscovery bubble now, the Sedona conference is considering a commentary on this, is Internet of Things. If I can just briefly, what do you see as the current challenge with collecting from Internet of Things sources? I know many folks talk about, with the data deluge and explosion that IoT brings, you have to engage in some type of proportionality analysis, but IoT brings so many unique data types. Where's the data located? Possession, custody, and control issues. Where do you expect the courts to land on this IoT issue? Or is it just another data source we have to consider and we shouldn't really get too deep in the weeds on it?
I think it's a little of both. I think that you'll find that the courts are going to have to wade into individual issues that are brought to them. So we had couple of years ago, there were some criminal issues related to, I think it was a murder charge and data that was potentially contained on an Alexa. And that issue never came to fruition, although Amazon filed a motion to quash the subpoena for the information, but it never got heard. There was never a decision on it. And so IoT data is problematic, right? But I think if you start to think about source-wise where the information goes, I have an Apple Watch, but the data from my Apple Watch is also on the apps on my phone. And then the data that's on apps on my phone may be on other Apple devices that I have. Do I use iCloud, whatever? You need to understand each individual device and how they store data, how data is managed, what data is available. I had a client call me one time and said somebody was in a boating accident and they were wearing an Apple Watch, but their hand was cut off. And so the watch might be at the bottom of the water. Would they be able to recover the data from the Apple Watch? And so, so then you're like, well, did he have his cell phone? And is the cell phone at the bottom of the lake too? Did the cell phone sync to the cloud? Because depending how quickly the Apple Watch was syncing to the iPhone and the iPhone was syncing to iCloud, you could still be able to recover that data using username and password to the iCloud account. So IoT data is hard. You do have to have somebody who knows how the data is maintained. Part of our job at ESI Attorneys is staying on top of that stuff for our clients and knowing what new types of data they're using, right? I mean, Slack is a huge issue right now. Slack just got bought. We don't know how Slack's going to change. We don't know how that's going to change the ability to collect from Slack. We know that people are now providing connectors from Slack into review platforms and converting the JSON file that comes out of Slack into something that's viewable in those eDiscovery platforms. We know that text messaging is still an issue. So from an eDiscovery perspective, we're still struggling with non-IoT data.
Right. Well, I wonder if a follow-up question is severed hand one of those 80 tags in eDiscovery?
No, it's not. It's not.
Well, another big survival tip and something we talk a lot about on the guide is reporting. And to be honest, with a lot of the matters I get involved with, and I'm sure you do the same, you're kind of coming in and remediating efforts that have already taken place. And oftentimes, there's a dearth of reporting with regards to those efforts. There's a master's conference blog piece that I read of yours from a few years ago in 2018, where you talk about the use of a working discovery report. I thought it was really interesting. It seems like it should be an obvious tactic and tip, but to be honest, you don't see a lot of reporting in that regard. Do you still use that type of reporting today, and has your use or how you suggest using a working discovery report evolved since you wrote that article?
We do still use, I think that article first was on Above the Law and then we put on the master's blog as well. The discovery report is a tool that we use for every single case. And that article, if you want to put it in the resources for this talk, lays out all the various sections of the report that we use. It starts with initial analysis of the case and goals from the clients and goes all the way through custodian interviews, identification of sources, date ranges, all of the decisions that are made and the basis for all of those decisions so that you can revisit them later. And yeah, those discovery reports are gold. We routinely revisit them in our cases.
There's definitely, there's so many different topics that I would love for you to come back. And I'd love to talk to you about defensibility and how those reports can support that, as well as how you actually practically analyze proportionality. But I know we don't have all day to do that, although obviously we could talk all day. But going back, dancing around a bit to the legal education state, if you will, you talked about the University of Florida, you work with the Master's Conference. One of the things I do a lot is work with law students. And I hear a lot of the concerns about entering the job market, especially in a time like this. Somebody like you who has such a unique path to where you are now, but has really done it so deliberately and with conviction and confidence. If you could give one or two pieces of advice for a new attorney entering the legal sector now, what would those bits of advice be?
Anytime I'm embarking on something new, I make a list of what it is that I want. Literally, what is it that I want to learn? What kind of people do I want to be around? What do I want my day-to-day look like? What do I want to wear to the office? What kind of office do I want to go to? So map out what it is that you actually want, and then look for those opportunities, because it gets really hard to sell yourself to opportunities that aren't really what you want. and you diminish your value when you start doing that. So I would try to identify what you want first and then go after that. There's a lot of talk about how many lawyers there are in the world, but there aren't enough lawyers for the people who need them. And I don't know, I wouldn't discourage anyone from going to law school, but I would encourage you to have some direction as to what it is that you want to do. You know, if you've been an engineer in a past life and know that you want to do patent law or copyright law, I think that's fantastic. You know, do your research on what part of the country you want to live in, and find the firms, if you want to work at an established firm, that do that work in that area. Rather than the shotgun approach, I suggest you take a really targeted approach in the same way that we do with ESI, I guess. So maybe those sound a little bit broad, but I think that when I started practicing, which I mentioned was a long time ago, it was really more incumbent upon you you had to choose litigation, corporate law, real estate, that kind of stuff. But when it came to litigation, you were really supposed to be a generalist. I mean, I was told for years to be a generalist. I didn't listen because I have that habit. But, I got into the complex commercial litigation, and that was what I loved, and that was what I stayed with. And so, but you really do have to specialize now. And so play around with your law school classes, see what you like, see what really interests you. What do you care about? I mean, being in complex commercial litigation is extremely different from advising clients on employment law issues. And you need to have a different kind of stomach to those two things. And right. So it's
definitely, a great tip. In law school, you have the folks that are going to be doing government work or maybe join legal aid or get involved with social justice. You had the folks that were running headfirst towards the 1% of the 1% type of firm jobs. And it seemed like there weren't many options. I mean, there were in terms of the firm you want to join, but in terms of what you could do with a law degree, no one ever considered, you can join a service provider, you could join a consultancy, you could join a forensic firm. And I think, that's a really good point that you bring up, to look at what you want to do and focus on that. To be honest, when I got out of law school, I took the shotgun approach. And I think a lot of times people just throw their resume out there and then they take what they get and then they kind of make it work. And I think that having the confidence and the strength to be able to decide early on what you want to do and to go after that, I think seems intuitive, but I don't think it's something people do a lot of. So that's definitely a great piece of advice. As we come towards to the end here, I wanted to note your love of basketball. We talked a little bit about this before we jumped on. So as somebody with an undergraduate degree and a JD from UNC Chapel Hill, I'm obviously a rabid Tar Heel. I was going to wear both my UNC Tar Heels sweatshirt, and I have some Rams branded shoes, but I didn't do that.
Yeah, because you knew I'd hang up if you did.
Well, look, I'm not going to hold it against you that. Yeah. And I learned that you're
vice versa. There you go.
I had a whole thing. I was going to ask about Marquette, but now I learned that you're a Kentucky fan. But I don't know if that really helps because A, they have similar colors to Duke. B, I was at that 2011 Elite Eight game in Newark where Kentucky beat us to go to the Final Four. And to be honest, I've only attended two tournament games since I've left UNC. It was that 2011 Elite Eight game, and it was the 2016 championship game against Villanova. And so now when it comes to the tournament, I don't even watch because I don't want to jinx the Tar Heels. But
I could do you one better than that. I took my 14-year-old son for his golden birthday, which I don't even think was a thing when I was a kid, but his golden birthday was 14, and he wanted to go to the Final Four, which, me being me with basketball was pretty easy sell, but it also happened to be in Phoenix, where my sister lives, so we could stay with her. And it was Oregon, South Carolina, Gonzaga, and North Carolina. Worst Final Four in the history of the world. The basketball was awful. Awful. And I can't even believe that North Carolina won, because those are four of the worst basketball games I've ever seen in my life. I guess it was three.
For all my UNC fans and friends, I'm sorry, we might cut that out of the.
Yeah, no.
But Kelly, What actually is your connection to basketball? Were you a coach? Were you a player?
I played basketball from third grade through my sophomore year of college. So
Awesome.
long time, long time. And then I grew up in Lexington, Kentucky, about 10 minutes from Rupp Arena. So I've been a Kentucky basketball fan my whole life. And that's really it. But I love basketball. And my favorite thing to do right now is watch my oldest son play basketball for
That's
his
awesome.
senior year. So
Yeah, I'm going to be in Kentucky late April, not for the Derby, but I'm running the Kentucky Marathon.
very nice.
Yeah,
Good
so
luck.
I've been itching to get out and get a race in, and it's been difficult, obviously. Most of the races are virtual, but they're actually, as of now, having it. But that brings me to one of my final questions. You're an athlete. You've been coached. You've been a coach. There's actually an article on the guide entitled eDiscovery Tips from Marathoners that I interviewed some folks on my professional side team that run marathons and are multi-sport athletes. But, what are the parallels you see? I mean, obviously that competitive spirit, that athletic know-how has infiltrated both your entrepreneurial spirit and your drive to kind of get these things done and find solutions. But what do you see with regards to parallels between success in the courtroom and success on the court?
Well, I've always been a team sport athlete. So soccer, basketball, football, whatever it is. And I can't imagine a bigger team sport than trying a case. So
Awesome.
for me, I used to say, and Sue, if you're watching, you can know this, that when I was at Quarles, Sue was my assistant. And if Sue wasn't coming in for the day, it was useless for me to come in for the day. And when we had a new case, I sat our team down, associates, paralegals, assistants, and said, this is what's happening. This is how we're going to do this. Everybody operates the same way. Here are our shared documents. Here's how we're going to manage things. And we had to be a team because work has to be divided up. You have to be able to count on what's happening with a team. And, at ESI Attorneys, the way that we work is huge team. I mean, we have to have providers that we work with. Maybe it's for forensics, or providers that we work with on other technology pieces that we don't have in-house. I work together with our attorneys and our paralegals. It's a huge team aspect just within our firm from a discovery perspective. And then we have to work with outside counsel. And so we have in-house counsel, outside counsel, and discovery counsel. And so there has to be a lot of collaboration. There has to be a lot of get over yourself kind of stuff. Usually the first conversation that I have with outside counsel is, hey, look, we're here to add to what you're doing and to make your job better and easier, not to step on your toes, not to be in any way an adversary between the relationship with you and the client, that we're all working together and we're all on the same team. Just consider us an extension of the client. And so it has to be a team game. It has to be a team game. And if you're trying to do it all by yourself, I think it's going to be very, very difficult.
That begs a third topic that I would love to come back and talk to you about, which is a skill that we often don't learn in law school, and that is often not fully developed even when we practice, is cooperation. Not just with the other side, but also with your own team sometimes.
Right.
So in that regard, that's a great parallel. So again, as we come to a close here, final question on eDiscovery. What are 3 items, if you had an eDiscovery survival kit and you could only bring 3 things, what would those 3 things be?
First thing that comes to my mind is the Federal Rules of Civil Procedure, but because I would want to have the case law that goes along with them, I guess I would probably say eDiscovery Assistant.
Yeah, I was going to say eDiscovery Assistant.
Simply because I need to have that guidance, right? You have to constantly be making decisions, and you've got to constantly be referring back to the law as to, what are the bounds for making those decisions. So that would probably be the first thing I'd take. Second would be the continued ability to always ask a question, even if I don't know the answer to it. The only way to continue learning about technology and to understand how technology works and to therefore apply legal strategy to it is to ask the question and not know the answer, right? You've got to be willing to put yourself out there. And the other thing that I would probably bring with me is the continued desire to learn about new things, because our job is pairing litigation strategy for any kind of case with ESI related issues. And I don't know every substantive area of the law. The areas that I have litigated, I know well. Other areas, I don't know that well. For example, right now we have a copyright case, and I'm always saying to outside counsel, help me understand exactly how this element works so that we can make sure the data that we're finding, that we're looking at, is what we need here. So it really is those kind of things, the desire to learn, the ability to ask questions that you don't know the answers to, and then, my resources.
That's about as comprehensive of an eDiscovery survival kit as you could have. So that's great. And finally, Kelly, you've created so many unique resources. You've pivoted so much in your career. You've created so much out there for the legal community, for all of us to help build competency and move the profession forward. So what's next? Can we see something maybe pivot outside of the legal community and all of a sudden start some kind of new business that no one's expecting, or building out what you've created so far? Or is there something new in the
always full of ideas, always full of ideas. You can ask anyone on our teams that, I am the idea girl, to say the least. But we're really building out eDiscovery Assistant right now and working to build that learning center that I mentioned. So there's a lot that we want to do there as far as education goes. I do have some other tricks up my sleeve, but we'll keep those on the down low for now.
Sure. Well, I did read that you're a prolific baker, and if there's one hidden talent I learned during COVID, it's that I wouldn't call it a talent. If there's one thing I've learned that I like, as I became hooked on the Great British Baking Show. Jonathan Armstrong from the UK a few days ago, we talked about that. But if this whole eDiscovery thing doesn't work out, maybe we can go into the baking business together.
Yes. Hey, there wasn't one time I was going to start a cookie making company, so I have baked a lot of cookies in my life.
That's awesome.
Yeah.
Well, I want to thank you so much. There's so much more that I'd like to talk about. Hopefully you'll come back and join us for a future installment. Any final words that you'd like to leave our viewers with?
I would say just keep exploring your limits, keep learning, keep growing. If you're pigeonholed right now, find a way to find a different opportunity for yourself, and keep growing, keep being inquisitive. So I'm thrilled to have all of you in the space, and if there's any way I can help anybody, feel free to reach out.
I couldn't think of any better parting words. And with that, this is Matt from ESI Survival Guide, hoping that all of you stay safe in the electronic wilderness. See you next time.
Thanks.